Thank you. I'm calling to order a code enforcement hearing of the City of Cape Canaveral. Today's date is October 24th, 2023. My name is Richard Geller. I'm Special Magistrate appointed by the City Council to hear code enforcement cases pursuant to Article 6 of the City Code and Florida Statutes Chapter 162. We're going to be having a series of quasi-judicial evidentiary proceedings. I believe one of them may be classified as a Massey hearing where an order was previously entered by me, and there is an issue as to whether there is compliance with that order. The burden of proof in all these cases would be upon the city to show by a preponderance of the evidence that a code violation either exists or continues to exist. In other words, I will determine based on the evidence presented to me this evening whether it is more likely than not that a violation has occurred or continues to occur. The alleged violator in each case will have an opportunity to submit any rebuttal or exculpatory evidence, including testimony. At my discretion, I may allow a member of the public with relevant personal knowledge to testify, even if not called by either the city or the responding party. Anyone who would like to testify we should have a sign-in sheet right there at the front of the chambers. Excuse me. Upon request, an alleged violator may ask relevant and material questions of any city witness, and the city may ask relevant and material questions of any witness for the responding party. I may exclude evidence that I deem irrelevant, immaterial, or unduly repetitious. Insofar as I'm called upon to determine the amount of a fine, I will consider the gravity of the violation, any actions taken by the violator to correct the violation, as well as any history of prior violations committed by the violator. Under the City Code and Florida statutes, I may assess and order payment of a fine of up to $250 per day per violation and up to $500 per day per violation for a repeat violation, or up to $5,000 for a violation that is deemed irreparable or irreversible, as well as the cost of any repairs made by the city. At the conclusion of the hearing, I will endeavor to issue findings of fact and conclusions of law based on the evidence of record, and will issue an order both here on the bench and in writing, which I always try to do the same week as the hearings. I'm not always successful at that, but I do make a good faith effort to do that. The city will record a certified copy of an order imposing a fine, which will become a lien against the land where the violation occurs, as well as upon any real or personal property owned by the violator. Any order that I issue may be appealed by any party, including the city, to the Circuit Court for Brevard County, Florida, within 30 days. It is the responsibility of the appealing party, whoever it is, to obtain a record of these proceedings. An appeal is based on the record that is presented to me. As an administrative matter, the city's agenda packet will be administratively accepted as City Exhibit 1, and its PowerPoint slides presented this evening will be Exhibit 2. I have signed and approved the minutes from the hearings held on September 26, 2023, and they've been given to Ms. Roth, our secretary. The next meeting currently scheduled is for January 24th, 2024. However, there is a possibility of a hearing held before the end of this year at a date to be determined. So at this point, I will ask if anyone who anticipates giving testimony to me this evening, if you would please stand and be sworn in. Do you swear that the testimony you will give this evening shall be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, I do.
Thank you, everyone. The first item on the agenda pertains to 348 Chandler Street, Alexander Gans, and it says in Jordan Carberry, case number 2023-332. Is the city ready to proceed?
Yes, sir.
Can I ask a preliminary question? I don't want to go far down the road if we haven't given all the notice that we're required to give, but I would note that I issued an order on this property way back in, I think it was December 2020, thereabouts. And at the time, the property was owned not only by a Alexander Gantz, but also there was a Jordan Carberry on that order. And I did not see,
She's no longer on it.
okay, so she's no longer a property owner.
That's correct.
Okay. I just wanted to make sure that there wasn't some notice that we omitted giving to Ms. Carberry, so she's out of the picture.
That is correct.
Thank you very much. I'll let you proceed then.
Okay, this is a vacation rental, a repeat offender violation, 348 Chandler. This is for the minimum stay advertising. The notice of hearing was sent out on 9/29/23, certified mail. As of today's date, it has yet to be delivered. However, the property was posted on 9/29/2023 in accordance with Florida Statute 162.12.
Okay.
On 7/3/23, I received a complaint from Joe Sojourner that 348 Chandler Street.
Can I just stop you? And was there also another notice of violation that was given?
Yes, sir. It was with the notice of hearing.
Oh, it was
Yes.
it was concurrently
Yes.
posted and attempted to
Yes, sir.
send via certified mail. Okay, thank you.
I received a complaint from Joe Sojourner that 348 Chandler Street is running for less than 7 days. Check of the Airbnb found the property is advertised in the calendar for a 3-day minimum. I emailed Alexander Gans and informed him of the violation and asked him to correct it. He replied back that it had been changed. I rechecked Airbnb and found it had been changed.
Oh, sorry, had or had not?
Had been changed.
Had been
It
changed,
was
okay.
corrected at that time.
Okay.
Then between the dates of 7/14/23 and 9/4/23, I received several complaints between these dates from Bob Fica, complaining he has witnessed renters staying for less than 7 days. On 7/25/23, I again checked Airbnb and found the calendar saying 5-night minimum. Mr. Alexander was again contacted by email and asked to correct it. He reached back out and said the issue is only for the month of September and all other dates are saying 7-night minimum. He corrected the September listings. I rechecked the Airbnb and it had been corrected at that time. On 9/21/23, I received another complaint from Joe Sojourner that this property again is renting for less than 7 days. I confirmed on Airbnb once again that the calendar is showing a 3-night and a 5-night minimum.
Just before you move on, I want to make sure I have so we have Joe Sojourner bringing this to the city's attention on July 3rd, 2023, as well as September 21st, 2023. And then we had another complaint sometime in July to September from
Multiple.
Mr. Fica.
Bob Fica.
FICA, thank you. And so, okay. And I seem to remember this one because back when this was first shown to me, we had different vehicles like every few days or every other day or so, or something of that nature. And then I also seem to recall that the way that the city would enforce the 7-day minimum is you could not, if a tenant or someone renting the property leaves before 7 days, the property could not be rented out again until the full 7 days has run its course.
That is correct.
Okay.
And they can't advertise in any way, shape, or form anything less than 7 days.
Okay.
So when I go through, I'm going to show you the Airbnb if you're ready, if you've got the dates ready.
Just one moment there. All right, you can move on.
This is the property in question on Chandler Street. So if you look at this and you click, you can see when you click on a date, to enter your dates, right above the 7 there, that's highlighted in black, it says 3-night minimum. So that is one of the issues there. That should say 7-night minimum. You shouldn't be able to click on another date until 7 nights later. So that's one of the things that we found. We also read in his own, the city of Cape Canaveral requires a 7-day minimum booking. The host will prorate rent for shorter stays over the required booking. Well, that right there is saying that he's going to hold himself out for less than 7 days.
So is it the city's position that even though you're enforcing the 7-day minimum by saying you cannot start a new rental for 7 days, you cannot hold yourself out as...
You can't, that's, I mean, the whole spirit of it is because these are residential properties next to people who live here.
Yeah.
And we don't want to carousel like a hotel. That's why we have zoning laws. So that's why we have the 7 days. So holding yourself out is, you know, the cruise industries are going to come out 1-2 days, and then, you know, there's a revolving door again. So now, with all of this said, I have been in contact with Justin Morowitz, who is the attorney for Mr. Gans.
Okay.
I talked to him several times yesterday, and we've emailed back and forth. And based on those conversations, I think there might be a misunderstanding of what he can and can't do.
Okay.
I've checked the database. Everything has been corrected as of today.
Okay.
They're this thing that I just read where contact him for a prorated, that's been removed.
Okay.
Everything says 7-day minimum now. I think he understands. I think he was under the impression that as long as he's blocking out 7 days, he could still rent out for 3. And we went over your orders from 2020 where it specifies, no, you can't do that.
Right, and the you can't have the next party come in for 7 days. That's just an enforcement mechanism that does not permit shorter
And we don't,
shorter rentals.
there's no evidence to suggest that there is a violation of multiple parties coming in that 7-day period. Everything is just holding themselves out. So with all of that, with the discussions I had, I mean, obviously you can make the determination. The city doesn't care to move forward with liens at this time.
Okay.
But that's entirely up to your discretion on how you want to do this. It's just, I was just, you know, dog chasing his tail with sending emails, and then the violation pops up again multiple times.
Right.
So I thought that it would be the best interest to just bring this before you and see what your determination is. But I have been in contact with the attorney, and I do believe that there might have been a misunderstanding.
Okay. All right. Is that
And that's all I have.
That's it for now? Okay. Is there anyone here to speak for Mr. Gans?
The attorney would be available by phone call if
Okay.
need be. If your determination is going to be negative, he would probably like to have something to say. If you're going to agree with the city, then there would be no need to call him.
If I agree that we're not going to issue any fines as of now, and it would be a very simple order, no fines issued tonight, then we don't necessarily need him unless he wants to speak.
Yeah, he didn't make it sound like he wanted to talk unless he needed to change your mind in some way.
Well, it sounds to me like it would just be a fruitless exercise if I'm going to rule in his client's favor and not issue a fine. So let's that will be my ruling. There will be no fines issued tonight. And of course, if there is any future non-compliance, I'm sure I'll hear from you again.
Absolutely.
But I'll issue an order in Mr. Gantz's favor as far as the issuance of fines goes. We'll probably find that there were violations. Yeah, I will find there were violations, but given the good faith efforts to comply, I'm not going to issue any fines tonight.
Okay, fantastic.
That's how we'll do it. And also, I'll mention the misunderstanding in the order.
That's it.
Okay.
Thanks, sir.
All right. Let's move on. The next matter is a appeal from determination of the fire marshal. The appellant is Kevin Orchard, Subject property is 7660 Ridgewood Avenue here in Cape Canaveral. Mr. Palmer, you want to introduce yourself for the record?
Yes, Brian Palmer. I'm the Deputy Director of CED and the Code Enforcement Manager. Okay, the property is 760 Ridgewood, as you stated. The legal and parcel ID are on the board. This is for the appeal of the fire inspection notice and determination by the fire marshal. The fire inspection notice was mailed on 7/18/2023 with a return receipt of 8/3/2023. Notice of hearing was sent certified mail return receipt requested on 10/12/2023. The last time I checked, it was still in transit. The notice of hearing was also sent via email to Kevin Archer on 10/12/2023, and he acknowledged receipt of the notice on 10/20/2023.
Okay, can you go back to that last slide? I want to make sure I have all the dates there. And so there was an acknowledgement of receipt on 10/20/23. All right.
Okay,
Very good.
just real quick, I'm going to let the fire department step up and kind of go over everything that happened and what they did.
All right.
They did issue a fire inspection notice to the property owner, and I'll let them speak on that right now.
Okay, thank you. If you could please state your name and title for the record, appreciate that.
My name is Jeff Roberts. I'm the fire inspector for the city.
Okay. You may proceed, Mr. Roberts.
Around June of this year, I did an inspection at 7660 for vacation rental. And the issue that's up right now is the third story bedroom. Code requires that it has a stair to grade or a residential sprinkler.
Well, so the way I understand it, and I'll let you educate me, so I may be demonstrating some ignorance here, but you need a primary means of egress and a secondary means of egress.
Correct.
So the primary means of egress to the ground floor, that could be your stairwell.
Correct.
Interior to the building. And then
Right.
for a secondary means of egress, there are a number of openings of windows. The fire department has to be able to with their ladders to be able to rescue someone. Am I kind of getting this right? Okay.
Correct. The codes that we're using is 509, Florida State Statute 509.215.
One more time. 599.215.
509.215.
Okay.
And the other is Florida Administrative Code 69A-43.018.
Okay. Wait. Let me write that down again. It's 60. One more time.
69A
Okay.
-43.018.
43.018. Okay.
And then that directs us to NFPA 101, Chapter 24.2, which
And then,
talks about the means of
okay. So when you say FPA, just so the record's very clear, it's the Fire Protection Act.
NFPA.
NFPA, National Fire Protection Act. Okay. And what are the numbers of that?
24.2.2
Okay.
speaks of egresses.
Okay.
Okay, so what the issue is with the secondary, you mentioned a primary and secondary means of escape. The code requires a secondary means of escape. 24.2.2.3, the secondary means of escape other than an existing approved means of escape shall be one of the means specified.
Okay.
It shall be a door, stairway, passageway, or hall providing a way of unobstructed travel to the outside of the dwelling at street or the finished ground level.
Is that primary or secondary?
That is the secondary means of escape. That's the definition for
Okay.
it.
So
The
door,
secondary-
stairway to the outside grade level. Okay.
That is independent of and remote from the primary means of escape. Goes on to say it shall be an outside in 24.2.2.3.3. It says that it shall be an outside window or door operable from the inside without the use of tools, keys, or special effort. It goes on to give our dimensions of the window that is open.
Right, it has to be like 2 feet high and then
24 by
so
20,
wide
correct.
and yeah,
Correct.
okay.
And so it also talks about either the secondary means of escape or the presence of a residential sprinkler.
So in other words, if a residential sprinkler system is installed, then you do not need the secondary means of escape.
Right. From the third floor.
From the third floor, okay.
They still have to have the secondary means of escape. The issue is at the third floor level, it's either a sprinkler system, residential sprinkler system, or this primary means of escape to grade, which is the stair.
Are the requirements different when you go from a second story building to a third story building?
Correct. There's a second floor is different. The dimensions of this and the need for the primary means of escape is the same, and the secondary means of escape are the same. It's just that it talks of 20 foot for a ground ladder for the fire department is second floor, so it's our position reading 69A that at the third floor level, our ground ladders no longer reach the secondary means of escape.
Okay,
And so that's where the option is the sprinkler system or a stairway to grade.
I see. So how high do your ladders reach? Do you know?
Our ground ladder is 24.
Please, yeah, and if you could introduce yourself for the record as well.
Derek Yosefon, I'm the Assistant Chief Fire Marshal.
I'm sorry, it was Derek.
Derek.
And what's your last name?
Yosefon,
Oh, okay.
common spelling.
Okay, Mr. Yosefan, and you're and what's your position again?
I'm the Assistant Fire Chief as well as the Fire Marshal.
Assistant Fire Chief and Fire Marshal. Got it. So do you know the answer to my question? How high do the city's ladders reach?
So we do have a ladder truck that has an aerial on it. However, the way the property's positioned behind it is an apartment complex that we cannot get that truck into. On that vehicle, there is a 35-foot ladder. However, it is not readily available to deploy in case of emergency. That's a truck that's stationed in the port, so the response time to that area could be delayed.
Okay, so let me try
The one in
to,
the area that would respond, the tallest ladder on that truck is 24 foot.
okay, so there's some geographic obstruction or positioning of where this third floor apartment is that
Correct.
makes it impossible for the ladder to reach.
Correct. There's a fence on the south side, and it's a very narrow walkway.
Okay,
So if there was a fire, all that's going to get congested. There's a fence all the way around it, and there's no access in the back of the property to get to that property.
is there a bird's eye view photograph that demonstrates this?
I believe there was one up. I do not have it.
Let's see. I think that would just help me to. Or if you want to just pull it up on Google Earth or Google Maps, just so I can really understand what the.
Okay.
Derek, do you spell your name D-E-R-I-C-K?
Derek.
D-E-R-E-K. Thank you.
And Yossifon.
Okay. All right.
Ridgewood.
7660 Ridgewood. I think it's, yeah, right in between there. Yep. It's the south of the south end
Okay,
of the
may
building.
the record reflect that I'm looking at a Google Earth image of the subject property, and I see Ridgewood Avenue on one side and then Aurora Court on the other side. And so do our fire trucks fit on Aurora Court? I mean, could that ladder reach?
It will not reach from Aurora Court
Okay.
to that unit.
Okay.
It's a duplex and he's the south unit.
Okay.
It's on the bottom. It has the
Okay, I see now. So, so the issue being that on the south side, there is shrubbery or some kind of vegetation that would prevent prevent the fire truck from reaching from Aurora Court, or could not physically go into that area between the two houses because the unit's on the south side. Okay.
And I even looked at the east end. There's directly to the east of the property, and there's a condo there where we have no clearance for the ladder truck. It's a very large
Okay.
apparatus.
Okay. So there were two, and I did look at the appeal, the written appeal, and there were two issues that were raised. One was there is access to a balcony. That was one. And the second was, well, what if we agree that we're going to lock the third floor? There'll be no access to the third floor by anyone who would be renting this property. What's the fire department's position on
Our
those two?
position, and it's not just this property. If we took the word of every individual that was going to be secured and not used, we wouldn't have a job. People are going to do what they do. I'm not saying he would, but code is code, and we follow the code for safety reasons.
Okay, so to lock that stairwell to the third floor with a deadbolt would not be acceptable
No,
from the
sir.
fire department's standpoint.
On fire department standard, our position is either a exterior stairwell down to grade,
Okay,
or he'll have to sprinkle it with the residential 13R system.
okay. And I don't know if you have this information or not, but what kind of expense to a property owner are we talking about to put in a sprinkler system? Are we talking tens of thousands? Is it?
Rough estimate, I would think probably 10,000 or less. And that's just ballparking. I'm not even sure. I'm not in
And,
that
and
business.
then, would the city, or has the city in other instances permitted, an exterior stairwell fire escape? Okay.
Not a fire escape, sir, but a ladder, a stair.
Okay.
Code compliance stair.
Yes, in fact, this was done in 2007.
I'm sorry, it was done where in 2007?
7916 Aurora Court.
Is that a, well,
Story, the same issue.
okay. I see, okay. Can we go ahead and mark that as an exhibit then? We'll make that exhibit 3. Do you need this back, or can I? All right, so we're going to make this exhibit 3. And if the respondent would like to take a look at this, you're welcome to do so, either now or before you go up. Take the time you need to look at that. I just want to mark it as Exhibit 3. City's Exhibit 3. Oh, I did already. Okay. All right, you can just give it to Ms. Roth. Okay. Okay, so I understand why the locking to the third floor. I mean, how does the fire department routinely conduct a fire inspection of properties?
On vacation rentals, it's no longer a single family or 1 to 2 family home. So they are up for inspection every year, just like any commercial business.
Okay. Then, so let's go to the other point that was raised in the appeal, which was that, well, there is egress to a balcony. You know, could someone get to that balcony and could they be rescued by the ladder?
No, because in here it says readily available ladder in the code, and that is not considered readily available to the HJ.
So are we talking about the ladder from one of the city's fire trucks?
Correct.
Okay, and so is it,
Plus, with the height and the climbing angle, it may not, we wouldn't know, we haven't put up a ladder there, there might be obstructions. The big obstruction would be people inside the building fighting the fire, because that, the only way to the back, to the balcony, is that narrow path that you saw.
okay, the narrow path on the south side of the building? Okay, which is covered with vegetation.
Correct,
And
you've got trees lining the south that divide the 2 units.
Okay, so the fire department's position is we could not avail ourselves of that balcony to rescue someone because of the vegetation and the limited space between
Correct.
the units on the south side.
Correct.
Okay.
And even if it was, the exit secondary escape is to ground level, not just to the balcony. They still have to get free and safety.
Okay. Is there anything else you all would like to present to me?
I don't believe so.
Okay, well, anything else, Mr. Palmer, before we turn it over to the respondent?
No, sir, the next.
Or actually, it's really the appellant, so I have it mixed up, I'm sorry. All right. I'll let you go ahead and present your case. If you could please state your name and address for the record, appreciate that.
My name is Kevin Orchard. The address we're here to discuss today is 7660 Ridgewood Avenue in Cape Canaveral, Florida.
Okay, and I seem to recall you reside in Windermere or somewhere? Okay.
I reside in 1805 Maple Leaf Drive, Windermere, Florida.
Okay. All right, Mr. Orchard, well, what say you?
So, I don't want to touch the keys on this. So, per my initial letter of appeal, like has been discussed here, which has been discussed a little bit today, is directly into the fire inspection that I received.
Yes,
right?
yes, and I reviewed that as well.
Yeah, and it did say, as we've been talking about, that the secondary means of escape shall be an outside window or door operable from the inside without the use of tools, keys, or special effort, and shall provide a clear opening of not less than 5.7 feet, the width not less than 20 inches, and the height shall be not less than 24 inches. The bottom of the opening shall not be more than 44 inches above the floor. Such means of escape shall be acceptable when one of the following criteria is met.
Yeah, and if I could just interrupt you for a second, I don't think there's any dispute over
Okay.
the size of the openings. So I think it's
Okay.
really a matter of this. I think you're relying on that balcony
Right.
as a means of compliance, and the fire department's position is, well, we can't get our ladders back there to the balcony.
Yeah, and until today, we did purchase a rope ladder, and we're told that that's not sufficient as well. And then, if I were to say, there is a driveway that faces west that's clear to the roof of the property, and you can walk right over the roof and easily access the balcony from the front.
Okay, and I'm just, do you have any kind of graphic showing what you're,
I have a picture on my phone.
okay, is this also, okay. What we can do, if you could pull it up on your phone, if you're able to take a screenshot and send it to us, that way we,
Would you like me to print a screenshot of the overview of it?
that would be terrific as well. So however we can document, so I can fully understand what you're saying.
Okay.
So,
Where would I send it?
well, hold on, Mr. Palmer is, he's working on it.
Right.
So while he's, so the west driveway, is this from Ridgewood?
Faces, yeah, Ridgewood faces the property.
Okay, and so your position is there's a driveway from Ridgewood that is, where there's clear accessibility to this balcony?
Not to the balcony, to the roof. And then you can walk right over the roof to the balcony on the third floor behind it.
Okay. I'm giving my visceral reaction, if, in case of a fire, I mean, seconds count potentially. And to require someone to go, so from the balcony to the roof and then wait to be rescued up there, but there's no, that's different from having that accessibility to the ground, without, relying on a hook and ladder to rescue. So I'm not.
All right. Like I said, this would all be right in case of emergency. So I was just trying to come up with some options to this property.
I appreciate that. I'm just, I guess my mindset right now is, which I think is similar to the fire department's, excuse me, to their, when they're looking at these types of issues is, what's the worst case scenario that happens here? And they have to worry about potentially, and I'm not saying this is ever going to happen, potentially if they have to rescue someone, if there is a fire, and then they have their own personnel and the safety of their own personnel that they're concerned about as well. So it's coming from two sides.
Which certainly we respect, and just as a way of providing options. The rope ladder was one that we thought would suffice. That did not. Deadbolting the third floor, as we talked about, which I provided a letter from the property management company here
I
in
saw
Cocoa
that.
Beach, who said that they would abide by those.
Right, and that's all in the record as part of the agenda packet.
Yeah.
I did see that.
That was another. Just to go through the timeline a little bit as
Sure.
well. So the fire inspection report was sent on May 8th.
Of 2023?
Correct.
Okay.
We talked about the potential for a rope ladder and a deadbolt on June 8th. At that point, during a phone call with Fire Marshal Yosefan, he suggested I could appeal to the state. I took that appeal to the state. They said, you have to appeal locally first.
Okay.
I did that appeal to the state on June 14th. On June 20th, Fire Marshal Yosefan said he didn't know of any local appeal process. That was on June 20th.
Okay.
On July 11th, I went back to the state and did file an appeal.
Okay.
I notified.
Well, I'm a little confused. I thought you filed your appeal to the state on June 14.
No. That was when I was told I could file an appeal to the state.
Oh, okay. So when told, and then thank you very much. And then
So when I talked to the state fire marshals, they said you had to go through a local appeal process first.
okay.
Which
And
then
so
on June 20th, I called back and was told that he would have to look into it.
all right. And I seem to recall in the letter that you received from the fire department that there was acknowledgement of the ability to appeal to me. So
Yeah.
that would give me jurisdiction to hear your appeal.
Which came later.
Okay. Okay, so anyway, so you appealed the state on July 11th, and then I assume at some point they kicked it out saying you have to go local. Do you know the date when that happened?
July 16th.
Okay, so they didn't waste any time saying, sorry, you gotta deal with this at the local level first.
Right.
Okay.
So then on July 18th is when the letter was mailed. We
Would-
received that on August 3rd.
Okay, wait, August 3rd, that's we're talking about the letter with stating the fire department's position, okay.
Correct.
So the fire inspection, I forgot the formal name for that. Let's see here. Okay, so letter received on August 3rd. Fire department. Okay.
So we appealed on the 4th and sent our appeal certified mail, which was received by the city manager's office on August 14th.
On August 14. And I don't think there's any, I haven't heard any argument that there's any
Right.
timeliness matter as
Well-
far as the appeal goes.
Yeah, I'm just, for the record, trying to
Sure.
state how this has been a process.
Okay,
Follow-up emails, the appeal was acknowledged on September 13th. You know, and one of the stipulations in the fire marshal's letter said within 30 days there'd be a hearing
okay.
of the appeal filed.
Well, of course, that could not happen because
Right.
I only do this once a
Just
month.
trying to get the timeline on record.
Sure, okay.
All right. And then the appeal date was set on September 25th.
I'm sorry, what was on,
Or on September 25th, I was notified of this appeal date.
okay.
And then did receive the notice on the 20th.
You received the notice of this hearing on September 20th?
Yeah. And to be fair, that was the second email sent to me. I was
Okay.
traveling for work and I didn't get the
Sure,
first email.
well, we're all doing our stuff.
So-
So that was the notice of hearing received September 20th, okay.
One of the alternatives that was given to us was the sprinkler system that we talked about.
Yeah, have you looked into the cost of installing that?
Yeah, so a couple different issues there. One of which said that there would need to be a water source that could be tapped, or they would have to reroute the city's water source into the property in order to install the appropriate fire sprinklers.
Was there any statement the city doesn't have pipes on Ridgewood? I mean, that's a pretty significant street.
Yeah, well, that's what we were told when we had the guy come over and give us the estimate, or like look at it, and he was gonna write up the estimate, and he told us some of what it would partake. And since then, we haven't been able to get a hold of this guy.
So you do not have any kind of cost evidence to give me on that?
Yeah, I mean, he gave us initial estimate, which was right around $20,000. He didn't know, but he said it was dependent upon the potential of having to reroute the city water line.
So, and then have you looked into the cost of an exterior staircase that would satisfy the city?
The issue with that is, as you can see kind of from the view above, and just, you know, looking at those sketches that were provided, the area in back of the property really is rather tight. I'm not sure that a structure of that magnitude could properly be built. I mean, that thing looked pretty wide across the whole back of a home, whereas ours is a little skinnier, it's narrow, and it's tall.
Well, I don't know what the dimensions are that would be required, but it seems. Well, let me ask this. So do you have this this image there,
Yeah.
this bird's eye view?
Right.
And I don't know if have I marked that as an exhibit yet? Let's call this, we'll call this City Exhibit 4. So can you help me to understand what am I looking at on the Aurora Court side? Or there appears to be something on the roof or in the roof there that is visible? Two different boxes?
Those are the balconies.
Okay. And so so we have, and this unit that we're concerned about is on the south side,
Correct.
and the fire department is saying, well, you have all this vegetation, and so they're concerned about their ladder even reaching the balcony. And then, and they're further stating that there must be secondary means of egress to the ground level. So, so I'm hearing some concerns about your ability to fit in some kind of exterior staircase, but I'm
Yeah,
not,
if you
but I'm not
see-
getting a real good
Well,
sense that it's impossible.
so if you see where our unit is, protruding, like separating the two balconies is those two little edges that come out.
Yeah,
So those are up about, I don't know, maybe they're slanted, but they're up about 15, I don't know, 12 feet, if I had to estimate. And then they come down, and then there's the wooden balcony rail in front of them. So,
Okay.
and again, it's skinny, right? You see the place next to it. So the really, I mean, and then right to the south side there is just a small little alleyway, sidewalk.
is the alleyway on the south side, or which
Yeah,
side?
The south side.
Okay,
And that's like, it's got a gate and a sidewalk that's probably 5 feet wide. That
Okay.
you walk, and then there's a side door to enter the first floor. And then that goes into the back, which has maybe 15 feet of an outdoor patio.
okay, and I cannot see the patio. I assume
Yeah,
that's
with
covered by
with the
by
trees.
by
Yeah,
the
there's
trees
palm
there.
trees back there.
Okay,
It's nice.
I'm sure it is. Okay, anything else you want to present to me tonight?
Yeah, I mean, there's really not, other than again, trying to just figure out what I think would be reasonable options
Yeah.
to this property. I will tell you, if it matters, that when we bought the home, it had been used as a vacation rental property for quite some time. So that's the nature in which we bought it specifically. And so this is new information.
All right. So my sense is you purchased it as a vacation rental. You're trying to follow the rules. You just want to make sure that if you have to do install a sprinkler system or add this exterior staircase, you're asking me to take a look at this and make sure that you really have to do that.
Pretty much.
All right. So what I want to, and I'm going to let the city come back, but right now I am leaning towards wanting to take some time on this and really looking at the applicable codes and make sure I'm fully understanding this and can render a decision that's in accordance with what these codes are saying. So,
And if there is a way to provide pictures, I took pictures, like I said, of the front, the third floor,
Okay.
the balcony, the area around it. So
and
you
I
really
don't recall seeing that in the agenda.
Well, I just thought of that on the way.
Okay, so
coming
why
here,
don't, why don't
I
we
can
do this?
send those.
I'm gonna allow you to submit any photographic evidence, any evidence for that matter, that you'd like me to consider by the end of this week. Is that fair enough?
Yeah, as soon as,
And then, so by close of business on Friday,
yeah.
anything you want me to consider as far as documentary, photographic evidence, I'm happy to take a look at that in conjunction with my review of these codes. And then the same goes with the city. If the city would like to present any photographic evidence, any evidence of any nature, I'm going to extend out everyone's ability to do so by the close of business on Friday. Then I'd like to hear from the city and Mr. Palmer. I don't know if you're, maybe we need someone from the building department, but this concern that was raised about, well, can an exterior staircase actually fit here? Do you have any insight on that?
He would have to get an engineer to come out and see if because it has to have a certain rise on it, it has to meet certain codes, the stairwell, or the stairway itself. So it would probably have to submit drawings to see if it meets code.
Okay.
So that would all be determined after the drawings and the permit application, everything was submitted. And, I mean, we don't even need to apply for a permit. We can submit drawings first, and the building official and the plans examiners can look at it and say, yes, that'll work, or no, that won't work.
So, so even before an engineer is obtained, there could be like an informal process where, you know, here conceptually is what we'd like to do, and can you give us your feedback? Is that kind of the idea here?
Yes, as long as it has all the measurements and everything that meets code, then he's going to go through it and look at it and say, yes, that meets code. Yes, it could go here. Yes, you're not going to, you know, step onto somebody else's property or what have you.
So before he were to hire an engineer and spend the whatever money,
Yeah, that would
that
be
would
fine.
be it.
Yeah, I would agree with that.
so it's like a conceptual drawings prior to engineer, just to get the city's feedback, from the building department's feedback. That may be a, and then, so just looking at this bird's eye view again, you said there's a driveway from Ridgewood,
Correct.
and there do appear to be some cars parked at the unit to the south, if I'm looking at this right. But that even seems further from the balcony, or you were saying that someone could go from the balcony onto the roof.
Yeah.
Well, I mean, if you got a house on fire, that
There's a lot you got to worry about with your house.
yeah, okay. Well, anyway, would the city or the fire department like to present anything else before tonight? Please.
So just want to state one thing. We follow the codes, not individual houses.
Right.
So going with the third, the locked door, that's not in code. We have to follow the code, not individual houses. As Mr. Orchard testified himself, that area is so small on that south side, getting a ladder back to the back of the building is going to be impossible.
Yeah.
It's very close, and even if we did get the ground ladder up, we may not have the proper climbing angle because of the vegetation. So, I mean, that just brings up even more safety, and as you alluded to, us climbing over a roof to make a rescue off a balcony that we have to raise someone, get them across the roof, and then back down the ground floor. If you have cars in the driveway, that's just not safe. That's not safe practice. I would never ask any of our firemen to do that.
Yeah.
And that's all.
Okay. Okay. Well, thank you, and let me give you my email address for the record. It's, let me know when you're ready. It's rgeller, RGELLER, at fishbacklaw.com, FISHBACK law.com. And when you send your materials, if you all would be, sure, rgeller, RGELLER, at fishback law, all one word, FISHBACK law.com. And when you send me whatever materials you would like me to consider, if you would be so kind as to copy Mr. Palmer on that, and then whenever I receive, I will forward it to the recording secretary, so she'll have the record as well. Patty, is that sounds good to you? Okay.
Real quick, I just want to get on the record. We were talking about the appeals.
Yes.
The appeal time frame. This actually falls under the International Property Maintenance Code. which gives a 20-day appeal process. He was well within that 20 days because the International Property Maintenance Code states that he has to just file for the appeal within 20 days. So he made that, he's good.
Right, I think I even said, I don't think there was any
Yeah.
question.
Well, I know that there was a 30-day in there. I just wanted to make sure that we got on the record that it was actually a 20.
20 days into the IPMC, yeah, that sounds right. Okay. All right, well, to be continued then on that, so thank you all very much. I think, do we have a third matter on the agenda tonight, if there's nothing else on this matter? There is a request for recall of code enforcement lien.
Yes, sir.
That's case number 2021-033. The respondent was Arturo Rodriguez. Is Mr. Rodriguez, and you all are free to go. Thank you so much. Could you, is Mr. Rodriguez here? I don't see Mr. Rodriguez. Is this Mr. Rodriguez's petition to be relieved of a lien, or what is this?
No, sir. This is, the city is going to provide evidence that the property is still in violation of your order, and the city is going to request to foreclose on or for you to direct the city attorney to foreclose on the lien.
Okay, so this is request for recall of code enforcement. So when you say recall, it's a request for foreclosure.
Yes, sir. It's actually the recall was a mispronunciation
So
of
it's
it,
a
I guess you would
foreclosure,
say.
okay.
It's an actual foreclosure of the code enforcement lien.
All right, well, I'm gonna issue an order authorizing, or actually, let's put on the record, if you could, if you have evidence of the continuing violations,
Yes, sir.
so we're real clear on this.
Okay. The address is 256 Polk Avenue. Legal's on the board. The violations are for property maintenance. This was actually, sorry, almost fell. This was actually presented to you originally back in 2021. You found it in violation.
Yes, May 21st, 2021.
Yes.
And I found violations of a number, a whole slew of
Yes, sir.
code provisions that we don't even need to recite them all, but
Exactly,
but because the record speaks for itself, all
Yeah.
these, yeah.
And you set liens at that point in time that were retro back to 4/29 of 2021. Magistrate order was sent on 6/2/2021. I'm sorry, it was the property was posted on that date. On 6/3 is when it was actually sent certified mail.
Okay, are we talking about, so the order here?
That was your order that.
It was posted on 6/2 and then 6/3/21 sent. Okay, so the certified mail was returned,
Yes.
but was posted, okay.
Notice of hearing was sent in 10/13/2023 with a return receipt requested, and it was returned to the sender. On 10/13 of 2023, the property was also posted in accordance with 16212 notices, along with the required posting at City Hall.
Okay.
I also have the actual code enforcement officer that first cited this property. He's here if you have questions for him. I'd like to go through the slideshow real quick
Sure.
for you. This is the property in question. As you can tell, this is the front of the property, and this was taken. The date's actually on the bottom, but you really couldn't see it, so I moved it up to the top.
Okay.
This was taken on February 16th, 2021. You've already seen these photos. This is how you ruled that he was still in violation.
Yeah, and just remind me, what was the what's
In
the
this
violation here? Is it-
Sure, in
was
this
it
picture right here, if you look at the top, you can see the soffits are missing.
Exactly.
You can also see exposed wood around the window frames.
Yep.
This photo was taken today. You can see that the property is still, if you look at the top, where we were looking just a minute ago, if you look at the top, the soffits are still missing. The exposed wood is still exposed around the windows. There's another closer picture of the soffits that were missing on February 16th of 2021. And that's a closer picture of today. Same, hasn't been changed, nothing's been done about it. This is a picture that was taken on February 16th of 2021 where you can see the soffits are actually kind of falling there in the picture. You can see that the fence has a gate on it and it still looks, you know, relatively in a good condition. This was taken today. You can see where the soffits have completely fallen and been stacked up beside the fence. You can see that the gate has been completely removed from the fence. It's fallen apart. You'll see it here in a minute. This was taken on February 16th of 2021. This is the trash and debris behind the fence. That portion of the fence to your left right there is actually the end of the gate that was actually attached at that point in time 2 years ago. This was taken today. You can see the trash pile is increased. And off to your right there, right beside the little Waste Pro trash can, you can see the gate.
Oh, right there in the grass.
Yes, sir.
Got it.
It became so dilapidated, I would imagine one of the neighbors got tired of looking at it because it was hanging off. It was a safety issue. Yeah. And I would imagine that I've gotten a lot of complaints from the neighbors about this. So I'm sure that they went out and tore it off and threw it in the backyard. Okay. This was taken on February 16th, 2021. As you can tell, if you look down at the grass area, it was actually kind of, you know, there was no trash and debris there at that point in time. And that's today. You can see where the trash and debris has gotten. And also in the back, it looks like some sort of addition to the Yes,
the house with an unfinished wall. Was that one of the violations that I had determined?
Yes, sir. That addition was actually put on without a permit. That was part of the whole issue at the beginning. This was taken on February 16th, 2021.
And that's that addition?
No, this is the other side. This is the west side of the property.
So that is where a garage door should go?
Yeah, I would imagine, yes, sir. And this was taken today. Somebody actually propped that white fence up. It was 2 days ago, it was hanging off. And somebody's gone over and I would imagine it's not the property owner. I would imagine it's one of the neighbors.
Let me just interrupt you. Sure. Because this is in my mind. Has the city looked into what kind of liens are on this property? Have you done any kind of title search?
Yes, sir, I have that.
Okay, all right.
Once again, February 16th, 2021. And I was kind of focusing on the soffits and stuff and the fascia.
Yeah.
And once again, you can see where that soffit portion of it actually fell.
Yeah.
Here's our lien breakdown of the property. As of 10/24/2023, today there's a $45,500 lien on the property. And that's the complete breakdown of it.
Okay.
And this, I think, was this provided to you in the, maybe not.
I don't remember seeing that in the, but I have it written down, the 45,500 in accumulated fines and lien.
As of today, yes.
And it's accruing at, if you go back, like $1,500 per month.
It's $100. It was $100 for the first day, and it's $50 every day thereafter. So it's accruing at $50 a day.
Okay.
This is the property appraiser details. And you can see in 2023, it was a market value of $431,860. The city attorney did do a title search on this property.
Yeah.
It is free of all encumbrances except for the city lien is the only thing on this property.
Yeah, because in some instances, cities may not want to foreclose on property when they're going to be taking the property subject to someone else's mortgage or that, but you don't have that here. Okay.
Absolutely not.
All right. Don't see anyone here representing the property owner. So I'm going to issue an order authorizing foreclosure. And please remind me how our code works. You need my authorization? Does that go to the city council, or you just need my authorization? Is that it?
No, it's just you're authorizing the city attorney to proceed with the foreclosure.
Okay, yeah, so I'm going to authorize that. I'm going to find the property in substantial noncompliance with the prior orders, that the requisite time has more than elapsed for the commencement of foreclosure, and that this property is an eyesore. It is a detriment to health, safety, and welfare of the citizens of the city of Cape Canaveral. And I'll get that to you this week.
Okay, excellent. Thank you, sir.
All right.
That's it. That's all we have.
All right. Thank you very much, everyone. Have a good evening.